Hi everyone, my name's Emma McGrath and I'm a member of the Employment Law team at Citation. In this webinar, I'm going to be advising on how to take effective disciplinary minutes. Every day, we advise clients using the minutes of the relevant hearing to understand what happened in the meeting. Good minutes are essential for us on the advice line as they give us a clear picture of what was discussed and then allow us to give focused, specific advice on the best way forward. However, good minutes are valuable for everyone in the process, including as excellent evidence for the future. One of the most important sets of minutes are in the disciplinary process. Although it sounds a relatively straightforward subject, it can be harder than it seems to write up good disciplinary minutes. On this essential topic, I'm going to be looking at why good disciplinary minutes are important, and then what makes a good set of disciplinary hearing minutes. So firstly, why are good minutes important? The quality of the disciplinary minutes is vital to having a clear and accurate record of what happened in the hearing. Good minutes mean parties have got easy evidence of exactly what was discussed, that the employee was treated appropriately, what procedures were undertaken, and the fairness of any decisions made. This is relevant for any future discussions with the employee and helping them to understand what has happened. However, should it become relevant, good minutes would also serve as key evidence in any appeal, internal complaint, or employment tribunal claim faced by the company. There are various minimum statutory requirements and good practice points which should be undertaken during a disciplinary hearing. Accurate minutes can evidence that the employer has undertaken these key action points. These include the following: that the employee was given the right to be accompanied, that the employee understood the purpose and potential consequences of the hearing, that no decision was made by the chair in advance of the hearing, that the employee received a full explanation of the case against them, that the employee had a chance to question any points on which they were unsure, that the employee had the opportunity to be heard and state their version of events, that the employee was asked at the end of the hearing if they had anything else they wished to put forward. I'll now talk about who should take the minutes. The minute taker does not take any kind of decision role in the disciplinary hearing. Instead, it is more about how good they are at documenting the discussions as they occur, and essentially that they can be trusted to keep all the details about the hearing confidential. They should also not be a witness or involved in the allegations being discussed. Our clients can sometimes struggle to find an appropriate person to take the minutes. They will then often ask us one or both of the following questions. As chair, can I take the minutes? Whilst this is possible, it is extremely difficult to run a hearing effectively and take minutes at the same time. So this is not something we'd usually recommend. Can I record the hearing? If there's no other choice, the chair could choose to record the hearing and then arrange for the minutes to be typed up afterwards. The typist should be careful, though, that this doesn't lead to unnecessarily detailed minutes, as they won't have the same time pressure when using a recording. It is also essential that all parties present in the hearing know it is being recorded and give their full consent. Some key action points for before the hearing. The minute taker should get a copy of the employee's invite letter, so they are familiar with the names of those attending and their roles in the meeting. Although this is probably stating the obvious, the minute taker should ensure they have plenty of paper and spare pens and pencils. It is also helpful to use margin-lined paper to easily initial who is speaking. Taking the minutes. The minute taker should use initials to indicate which person is speaking, and then record the essence of what they say. Whilst this should not be word for word, it is important that the summary sentences accurately record all the points that were made and facts that were presented. It's a good idea for the chair to check with the minute taker every so often to see if they need a moment to catch up. Flow of the minutes. No disciplinary hearing will follow exactly the same format, and it is important that the chair doesn't feel confined to a script. However, in terms of a framework for taking the minutes, the minute taker might expect to follow something along the following guidelines. Note the date, location and start time of the hearing. Make sure all names and job titles of those present are written against the role they'll be undertaking. Note if the employee is being accompanied by a representative. Record the reason for the hearing or the allegations, as stated by the chairperson, and record the process that will be followed. Record the employee's responses to the case against them. Ensure all evidence, documents presented or discussed are captured, e.g. dates, timings, witness names, reports, etc. Ensure all questions asked are captured, followed by the employee's responses, to illustrate a two-way dialogue. Record any adjournments. Record the summing up. Record when a decision is likely to be made. Record the close time of the hearing. Finalising the minutes. At the end of the disciplinary hearing, all parties should read and sign each page of the minutes to confirm they are a true account of the hearing. If the employee disagrees with something and the chair or minute taker does not accept the point, then the minute taker should record the employee's objection or comments as a side note on the minutes. It is not necessary to completely agree the minutes before a disciplinary decision can be made. Following the hearing, the minutes should be typed up so they are easily legible in the future. If there is any technical jargon in the minutes, it may be useful to include a plain English definition as well. Finally, a copy of the minutes should be provided to the employee and a copy held in the employee's records, along with the original handwritten notes. Thanks for listening. At Citation, we are experts in all areas of HR and employment law, from the small topics to the large. Hopefully, though, this webinar has helped to show that even small topics can be vital ones. If you've got any questions, then please do give us a call.